Good morning, sir.
Good morning.
Sir, I'm Vikas Gaur, Inspector. I have recently joined the department, sir, and I recently heard that government has announced an amnesty scheme for the waiver of interest and penalty regarding GST liabilities. So I've come here to more about it, sir. Please elaborate on this, sir.
Because I will be glad to explain to you. First, I will tell you about the basic features of the scheme. The scheme is intended to give benefit in respect of interest or penalty for the demand raised under Section 73 for certain tax period subject to the fulfillment of certain conditions prescribed. The demand should be for the period 2017-18 to 2019-20. For those cases only, this benefit is available. And first and foremost, the demand has to be raised under Section 73. And for implementing the scheme, government has introduced Section 128A and also they have inserted Rule 164 in the CGST rules.
Okay, sir. Does that mean that this scheme is not applicable to the demands that are raised under Section 74?
Yes, the scheme is not applicable for those demands raised under Section 74 involving suppression of facts, willful misstatement, or fraud. In those cases where the appellate forum or the court has held that it is not sustainable, that the demand under Section 74 is not sustainable, and they have asked the adjudicating authority to redetermine the demand under Section 73, then the scheme is available. In such cases, they have to file the application within 6 months from the date of redetermination of the demand under Section 73.
What are the situations under which this scheme is applicable, sir?
The scheme is applicable in the following situations: where notice has been issued under Section 73 but no order has been passed, where order has been passed under Section 73, where appeal has been filed with the appellate authority and order has not been passed, where appeal has been filed with the appellate authority and order has been passed, where the revisional authority has stayed the order of the adjudicating authority, where the revisional authority has passed the order, and in case of appeal filed in the tribunal but no order has been passed.
Does that mean that this scheme is not applicable for those cases where your tribunal has passed the orders confirming the demand?
In those, yes, the appellate remedy has to be pursued and they cannot file application for waiver of interest or penalty.
Okay, sir. And what about if taxpayer has paid some amount as interest and penalty, whether taxpayers are eligible to claim that amount as refund, sir?
In such cases, the taxpayer cannot claim refund of the interest or penalty already paid.
And sir, whether the taxpayer can go for the waiver application even if they have gone for the appeal or writ?
In cases where they have gone on appeal or writ, they have to withdraw the application first before filing the waiver application.
And what about in those cases where the taxpayer has already withdrawn the appeal but the order of withdrawal has not come till the date of filing of application of waiver? So in those cases, what should the taxpayer do, sir?
In such cases where the order for withdrawal has not been issued by the concerned authority, the taxpayer has to file the application for withdrawal along with the application for waiver of interest or penalty. Once he gets the order regarding the withdrawal of the appeal or writ, he has to file it within 1 month from the date of receipt of that order.
Okay. Now, sir, one very peculiar situation arises. What happens if the taxpayer withdraws the appeal but the application for waiver gets rejected?
If his application for waiver of interest or penalty gets rejected, then the appeal will be restored in the appellate forum. In respect of writ, he has to again approach the court for getting the remedy.
Okay, sir. What are the various conditions that have to be met for availing the benefits under the scheme, sir?
To avail the benefit, full payment of tax demanded in the notice or the order has to be made by the taxpayer, and he can exclude the amount demanded or confirmed under Section 16, subsection 4, for which there is a waiver under subsection 5 and subsection 6 of Section 16. He has to pay the amount before 31st March 2025.
And sir, what are the various forms used for filing the application for waiver of interest and penalty, sir?
In respect of notice issued under Section 73, the taxpayer has to file the application in form GST SPL 01. In all other cases, he has to file application in form GST SPL 02.
And sir, can payment of tax can be made through DRC 03?
No, the taxpayer has to make the payment in the electronic liability register. He cannot make payment through DRC 03. Suppose he has made the payment through DRC 03, then he has to file DRC 03A to credit the amount in the electronic liability register.
And sir, whether the taxpayer can file a single waiver application even if multiple notices or orders have been issued?
No. If multiple notices or order are involved, then he has to file a separate application in respect of each notices or order.
Whether this scheme is also available in the case where the demand in the notice or orders covers the period from 2017-18 to 2019-20 and beyond.
Even in such cases, the benefit is available for the period up to 2019-20, subject to the condition that he pays the tax demand for the period, entire period, including the period beyond 2019-20.
And then what happens if the department finds that the application is liable to be rejected? And then in that case, what are the steps that have to be followed and whether any notice has to be issued to the taxpayer before passing of the order?
If on examination of the application, if it is found that the application is liable for rejection, then the proper officer has to issue show cause notice within 3 months from the date of receipt of the application in form SPL 03. The taxpayer has to reply within 1 month, 1 month from the date of receipt of the notice in form SPL 04. The proper officer has to grant a personal hearing before passing the order. In case the proper officer finds that the application is liable for rejection, then he has to issue order in form SPL 07. In case the proper officer finds that the application is acceptable, then he has to pass orders using the form SPL 05. The order has to be passed within 3 months from the date of receipt of reply, and in case where no reply is received, then he has to pass the order within 4 months from the date of issuance of notice.
And sir, what will happen if the order is not passed within the time limit?
If the order is not passed within the time limit, then it is deemed to have been accepted.
Okay, sir. And who is the proper officer for passing the order for this application of waiver of interest and penalty, sir?
In case of application filed under SPL 01, the proper officer is the adjudicating authority. In all other cases, the proper officer is the jurisdictional deputy commissioner or the assistant commissioner.
And whether the taxpayer can go for appeal or writ against this order of rejection, sir?
Yes, the taxpayer can go on appeal against the rejection order, and in case the appellate authority finds that the taxpayer is eligible for that waiver of interest or penalty, he will issue order in form SPL 06.
And whether the benefits under the schemes are also available in case of IGST and compensation cess?
Yes. In case of demand under IGST Act or under the Compensation Cess Act, in those cases also the benefit is available.
And so whether this waiver is also available for the redemption fine and late fees?
No, the waiver is not available for late fee or redemption fine. It is only applicable for interest or penalty.
And sir, whether the payment to avail the waiver under section 128A can be made by utilizing ITC?
Except for the demand of tax to be paid under RCM or by e-commerce operator or erroneous refund given as cash, they can utilize ITC for payment of this tax demand while claiming the waiver of interest or penalty. They can also pay in cash in case there is insufficient balance in the ITC.
And sir, whether this scheme is also applicable in the cases where the demand has been dropped by the education authority, but the department has gone for appeal and the appellate authority, tribunal or court have confirmed the demand.
Yes, in such cases also the relief is available to the taxpayer subject to the condition that he pays the additional amount determined by the court or the tribunal or the appellate authority within 3 months from the date of passing of that order.
Thank you so much, sir, for clarifying all my doubts on this amnesty scheme on waiver of interest and penalty on GST liabilities. Now I got a fair bit of idea about this scheme. So thank you once again, sir, for clarifying all my doubts.
Thank you. If you need any further clarification, feel free to contact me. Have a nice day.